Have you ever wondered how the sausage is made at your state capitol? At Gazelle Consulting, we had the honor, nay, the privilege, to participate in the development of House Bill 3284. This bill established provisions for protecting data relating to contact tracing during COVID-19. This bill is important because many businesses that don't typically handle health data, such as your local grocery store, concert venues, and app developers, will be playing their part in controlling the spread of COVID-19. But we want to ensure that once they are done using that data for COVID-related purposes, that they dispose of it securely and that they are limited from using, selling, or advertising with it. Please enjoy our testimony.
My name is Ellen Rosenblum, and I'm the Attorney General for the state of Oregon, and I am here in support of House Bill 3284. And as mentioned, we have a brand new -2 amendment that is the most current version of the bill. This work has done much to keep Oregon abreast of ever-changing developments in the intersection of privacy and technology. And this work is both incredibly important and continuously evolving. Consumer data privacy and control over it is also increasingly a fundamental issue of equity and civil rights. This task force has been working diligently on the development of comprehensive privacy legislation that relates to the right of consumers to know how their data is being used, the right to correct errors in personal data, the right to restrict how and if data is processed by a company, special protections for children and minors, and how these laws should be best enforced. Without such protections, there's no assurance that this sensitive data won't end up in the hands of insurance companies, employers, creditors, identity thieves, or stalkers even, to be used in ways that could harm or discriminate against individuals. That is why House Bill 3284 is a crucial bill for Oregonians, and one that we hope will serve as a model for other states. Kimberly McCullough, our legislative director, is here to provide you with the mechanics of the bill. These amendments are very much breaking news, so I'm going to, if that's agreeable with the chair, turn it over to Kimberly at this time.
My name is Kimberly McCullough, legislative director for the Oregon Department of Justice. We've included a broad definition of personal health data. It's any information that identifies or can reasonably be used to identify an individual that's collected for the purpose of detecting, tracking, monitoring, or tracing an individual's exposure to or infection by COVID-19. In addition, that includes information that can associate an individual with exposure to a person who has COVID-19, development of symptoms, COVID-19 tests or examinations, receipt of COVID-related medical care, predisposition towards developing a disease condition that results from the exposure to or infection by COVID-19, vaccine status, and geolocation data or other data that can be used to track our exposure or infection. So anyone who collects, uses, discloses, or discloses personal health data, or who develops or operates a website, web application, mobile application, any of those types of technologies that collect, use, or disclose personal health data is covered. This does not include public health authorities. It doesn't include your healthcare provider, so your doctor, or entities that are covered by HIPAA for their HIPAA-covered activities. You'll see that there are provisions that prohibit covered organizations from the collection, use, or disclosure of personal health information, health data, without affirmative express consent. You'll also see provisions that prohibit obtaining consent through the use of what are more commonly known as dark patterns. Dark patterns are user interfaces that have been carefully crafted to trick users into doing things like buying or signing up for something. The bill clarifies that only the personal health data that is reasonably necessary to provide services to the consumer can be collected, used, and disclosed. So to put this into context, you sign up for an application, you give your affirmative express consent, and then really that data can only be used for the contact tracing app. You'll see that covered organizations must provide a way to revoke consent once it's given. So not only can you opt in, but you can also opt back out, and they're going to have to honor that and stop collecting your data. And this is followed by requirements that the covered organization provide information to the consumer in transparent policies.
Chair Power and members of the committee. My name is Christina Glabas, and I'm the owner and founder of Gazelle Consulting. So I've got a lot of experience seeing the different kinds of challenges that different varieties of organizations deal with and how flexible laws like HIPAA give organizations the ability to use the data while protecting consumer privacy. There are exemptions to this law for HIPAA-covered entities, which as well as business associates, and business associates are service providers to covered entities to the extent that they are engaged in activities covered by HIPAA. Amazon's got contracts with healthcare providers, but we don't want them to use that data for purposes that are not explicitly outlined by the business associate agreement. Additionally, our revision to the bill updated the de-identification requirements to match HIPAA de-identification standards. I believe this bill is absolutely necessary to protect Oregonians and establish a framework for addressing data privacy in emergency and disaster situations. So the language in the bill has been revised to include an updated definition of geolocation data, which applies to any technology that could be used to identify an individual's location. The revised language in the bill also explicitly limits covered organizations from using personal health data for training machine learning algorithms related to or for subsequent use in commercial advertising. It has been a true honor to participate in the development and revisions to this bill. A.G. Rosenblum, Kimberly McCullough, their team at the DOJ, and the team that they have assembled for the privacy work group are an impressive representation of consumer advocates, technologists, privacy specialists, and major technology companies. With these revisions, I believe the bill will go far in protecting Oregonians and allowing businesses the flexibility to use the data to support their operations in an ethical way. Thank you.